Okay, why don't we get started? I'm Sam Zakharoff. I teach here at NYU, for those who don't know me, and together with Rick Pildes, I'm one of the hosts for this event. This is our last session. We have one substitution. Alex Kesar from the Kennedy School, who is writing a book on the Electoral College, could not make it, and so we thought desperately, could there be two people writing books on the Electoral College? And we came up, Jesse Wegman, who's from the editorial board of the New York Times, is, as of 2 days ago on book leave, writing a book on the Electoral College. So
I actually decided to take that leave as soon as I was offered a spot on this panel and write the book.
So let me just go across and just very briefly introduce folks. So Jesse Wegman, who's also a graduate of this law school, and next to him is Michael Waldman, who's also a graduate of this law school. Michael is the director, I think that's the right title, is that right? President? What? President, okay. President of popularly elected president of the Brennan Center, which is affiliated with NYU Law School, which does a lot of democracy, public work in both litigation and non-litigation. And then we have Melissa Schwartzberg from the politics department at NYU, and Melissa walks across a lot of domains in political science. You first introduced yourself to me as a political theorist. I don't know if that's still accurate or not. On my right is Kate Shaw. Kate is a law professor at Cardozo Law School. She was in prior lives a law clerk to Justice Stevens. She worked with Bob Bauer in the White House counsel's office. And to her right is Rob Ritchie, who for a number of years now, I can't quite remember how many.
26.
Oh my God. Has been the director of Fair Vote, which is a group that has been advocating on behalf of certain kinds of structural reforms in the electoral process, originally heavily geared towards single transferable votes, and now they are behind the reforms to ranked choice voting, including what is going on in Maine right now, which is absolutely fascinating. So this panel is organized initially around the Electoral College, but let me give a slightly broader perspective. In the last panel, Bert Newborn talked about the need to be romantic, and sometimes romantics realize things. And the kind of romance that many of us enter into our lives is our courtship rituals, which sometimes yield results like marriages. So I decided we put together a panel of all married people, and so on the assumption that maybe romantic aspirations are worthwhile. So here's an issue that the way I started thinking about this problem. We want to start the Electoral College, but there's a number of them. In the 2000s, I would ask my students a question, and this was a concern about the Electoral College. I would say, what were the issues that were being debated, the hot button issues, in the election of 2000, the Bush-Gore election? And so there's a lot of, students tend to be young, so they have no memory, and there's a lot of present day reading back, hindsight bias. And so they would assume it was things like the risk of terrorism, because this was in between had come 9/11, or the restructuring of the financial system if it was around 2008 and they were dealing with the collapse. And I'd say, no, actually the issue in the 2000 election was the lockbox. And the lockbox was a completely stylized nonsense debate. It was also, Al Gore had this idea that he was building a bridge to the 21st century. And that didn't even work as a metaphor. But the lockbox was protecting the Social Security surplus. And why was that an issue? It was an issue because there were only two states that were thought to be seriously in contention in 2000 and were going to drive the result: Pennsylvania and Florida. And what unifies Pennsylvania and Florida? Florida's number one and Pennsylvania's number two in percentage of the population over 65. And so you had an election driven purely by sectional concerns. Mass transit didn't make it. I, at the time, lived in New York. Petrochemical, energy dependence, all those sorts of things, which I used to live in Texas, that didn't make the cut. None of the issues that affected the rest of the country were as important as the Social Security surplus. And so, to me, that is an institutional failing of the current manifestation of the Electoral College. And it's an institutional failing in several ways. First of all, it consolidates the sense that in presidential politics, most of our votes don't count. If you live in New York or Texas, you'll never see a presidential ad on television. Your votes are just not up for grabs. And so there's no effort to reach you. But it also is a kind of failing of the original mandate of the Electoral College, at least part of the debate. Part of it was largely formalizing the slave compromise in the original compact, but part of it was also a concern that if we were going to transcend the Articles of Confederation, if we were going to have some kind of federal system, that there had to be a way of stopping sectionalism in the selection process for the president. There had to be some institutional mechanism that forced presidents not just to run to the population centers or the dominant places. And now what we have, it seems to me, and this is where I started writing about this issue, it seemed to me that we had recreated that problem. And so there are two major challenges to the Electoral College, and then I'm going to turn it over to Jesse to talk about how this cashes out historically. There are two major challenges. One is the system that has been proposed, and a number of states have passed it, of the National Compact and the Popular Vote Compact, in which you don't have to amend the Constitution. All states, or a certain number of states, having more than half the electoral votes, Electoral College votes, would form a contract to give each other to give the votes, their electoral votes, to whoever wins the popular majority nationwide. So basically, the popular majority nationwide would bind the results across the states. Some people, like myself, have some constitutional issues about whether you can form this kind of compact without going through the Congress. Some people, like myself, have a view that the first time it comes out against the way the Texas legislature wants to go, they'll breach it and there's no enforceable remedy, but that's one thing. There's another group who's even crazier, and I'm part of that, that believes that you can attack the winner-take-all feature of the Electoral College at the state level, and that it's basically the application of minority vote dilution principles to the question. And so we filed suits in 4 states, California, Texas, South Carolina, and Massachusetts. In California and Massachusetts on behalf of Republicans, in Texas and South Carolina on behalf of Democrats. I may have gotten California and Massachusetts on behalf of Republicans, the other 2 on behalf of Democrats. And the idea being our votes don't count. Our votes are completely discounted. And it's not constitutionally mandated that winner take all, because Nebraska and Maine don't have that. There's nothing in the Constitution. It's in such manner as the state legislature shall see fit, but they can't do it on an unconstitutional vote dilutionary basis. That's at least the theory. So these are challenges, and these seem like pie in the sky ideas. And so how did we come to believe that what is has to be? Because it came about from something initially, and what has been the history of it. So, Jesse, why don't you start, because there have been times when this has been thought to be up for grabs.
Right. I want to just start just by saying thank you for inviting me on this panel. As Sam said, I was a student here. I graduated in 2005. I'm sort of the opposite of a prodigal son, because when I was here, I did not distinguish myself, but I returned to my natural habitat, which was journalism, and have been welcomed back here and really have loved to stay connected to this community, to this legal community, and to this intellectual community ever since. And so I'm really thrilled to be a part of this conversation and this conference today. As Sam says, this is when we talk about the Electoral College, we really do have to talk about it with an understanding of its history and an understanding of the debates over it throughout history. So I want to just frame the discussion a little bit before we get into it. We've experienced, in less than 2 decades, we've now experienced 2 split elections where the Electoral College overrides the popular vote. And I think many people could take from that, and the debates that those elections have engendered, these very sort of heated, emotional debates, that our fights over the Electoral College are new ones. But they're not. I'm assuming that everybody marked September 29th on their calendars this year. Is that right? Well, if you didn't, like I did, you should know that it is one of the more underappreciated anniversaries in modern U.S. history, I think. And that's because it was that date in 1970, September 29th, that the very last meaningful effort to abolish the Electoral College died on the floor of the U.S. Senate. Most people don't remember that this happened. Even people who were politically sentient at the time have forgotten completely about it. What happened, very briefly, was that starting in the mid to later 1960s, and driven by Senator Birch Bayh, who was at the time the chairman of the Subcommittee on Constitutional Amendments, the Congress essentially moved through an amendment to abolish the college in favor of the popular vote. That began in 1966. We're just in the aftermath of some pretty dramatic democratic reforms in the country, from the one-person, one-vote rulings of the Supreme Court to obviously the Civil Rights Act and the Voting Rights Act. And Birch Bayh signs on. He has just actually shepherded through the 25th Amendment on presidential disability, which has surprisingly come back into vogue recently. So he was seen as an extremely influential member of Congress, and he took it upon himself. He was first convinced himself that the Electoral College was doing grave damage to American democracy, and then he took it upon himself to convince the rest of his Senate colleagues and the members of the House of Representatives to agree with him. So that a couple years of extremely extensive hearings in Congress, the nation was riveted, actually. This was like front page news for quite some time in the late 60s. And then in late 1969, the House overwhelmingly passed the amendment. I think the vote was 338 to 70. So it moved through the House, and then it went to the Senate. If it passed the Senate, it was going to go to the states, and at the time, around late 1969, according to a New York Times survey of state legislatures, 44 state legislatures had a majority support for the amendment. So the Senate was the one barrier at this point. They get it. It goes. I don't know the other people here. I'm sure know the procedural niceties of the Senate better than I do. But it got into the Senate. It was scheduled, and it got blocked by a filibuster. The filibuster was led by Strom Thurmond, Jim Eastland, and Sam Ervin. And you might remember them as senators from the South who held segregationist views, and surely understood that what the Electoral College had done for them in the past. So September 29th, 1970 was when they had the final cloture vote trying to end that filibuster, and it failed by 5 votes. So with 5 votes, this bill would have gone to the full Senate, and had it gotten through the full Senate, which I think there was a chance it would have gone to the states, and with a very good likelihood of being passed, and then we would have that amendment. I just want to point out, by the way, this is just an interesting historical aside. Birch Bayh is the only person in United States history, outside of the Founding Fathers, to successfully pass 2 constitutional amendments. He moved the 25th on presidential disability, and then a few years later he moved the 26th on lowering the voting age. If the ERA gets 1 more state to ratify it, he will have gotten 3. And if the Electoral College had gotten 5 votes in the Senate in 1970, he would have 4. So a pretty remarkable record for one person. Senator Bayh got as close as anyone has ever gotten in United States history, but he's far from alone. In fact, there have been more than 700 attempts to amend or abolish the Electoral College in the history of the country, which is far and away the most of any one clause of the Constitution. So why is that? Why have we been fighting about this one clause or these a couple clauses for so long? It goes right back to the founding and to the Constitutional Convention. And this is I think where it's worth just remembering why we have an Electoral College in the first place. It was one of the most heated issues that was debated at the convention. It was debated on 21 different days. They held 30 votes over the course of the 3 or 4 months of the convention on the issue. Most of them failed. The central issue that they were dealing with at the time surrounded suffrage. And I think, I was thinking back to just now to John Haidt's interesting talk, and I think he's right that the Founding Fathers came to the creation of this country with a sense of fine-tuning and calibrating this new democratic experiment, and that they had many parameters that had to be just right. And I don't think we can overlook the fact that one of those parameters was the ratio of 3/5. And that was clearly central to the success of the Constitution at all. And of course, in the transferring of the House and the Senate representation into the Electoral College votes, it was now baked into the Electoral College too. So the preservation and protection of the power of the slave states was really central, I think, to every part of how the Constitution was written, and also, therefore, to the Electoral College. If you doubt that, take a look at who was president for the first 40, 50 years of the nation's life. It was Virginia slaveholders. There were also other interests that were being addressed by the Electoral College. One of them was the small states, who had just won through the Connecticut Compromise their equal representation in the Senate, and they did not want to suddenly lose their power. But you'll note that there have only been 3 small state presidents in US history. So who really benefits from the Electoral College over history? It's not the small states. It was the slave states, and today it's the swing states who, just by chance, have become virtually split 50-50. And there's only a few of them every election. So as Sam said in his introduction, I think is one of the biggest strikes against the college, it's not just that it elects the wrong person sometimes. It does, and that's a very big problem, I think, in a democracy. But it essentially disenfranchises more than 100 million voters every 4 years who nobody cares about. Presidential candidates don't visit them, ads don't run, money doesn't flow because they're not trying to pick up those votes. It is a distortion, and it is an extreme distortion of the political process. So I think that sort of, that brings us, I think, to today, where we have now 700 attempts later, we're still having this debate. And I think the bottom line as we have that debate once again, and I hope we continue to have that debate as long as, until I can get my book out, is that the Electoral College was designed for a country so dramatically different from ours today as to be virtually unrecognizable, right? We know some other parameters that the founders were working with. 6% of people were voting. Black people were not considered human, except for the purposes of representation of the white people who owned them. White women were not considered fully human. Our conceptions of democracy today are so vastly different from what they were in 1787. And it's really hard to talk about the wisdom of the framers who designed a system for that other reality. And I think the reason that, to come back for a minute to Birch Bayh, the reason that his effort came so close, it's really interesting. Think about when that was, 1968, 1969. When was the last split of the Electoral College at that point? It was 1888. Benjamin Harrison wins the Electoral College. So 80 years, basically nobody was alive anymore who had even lived through a split election, and yet we get this close as we ever have in American history, to abolishing the college. Why was that? I think it was for a number of reasons, but a few were the ones I mentioned earlier, is that you had these sort of tectonic shifts in how people thought about what democracy is, what America is, and who is included in that democracy, from one person, one vote, to the Civil Rights Act, to the Voting Rights Act, these sort of earth-shaking expansions of the franchise. I think 50 years later, we're in a similar place of rethinking what democracy means. Obviously, the current administration is making us all rethink what democracy means. But I think there is more ferment and more turbulence, obviously, right now than there has been in quite a long time. And I think it's not a mistake, it's not a coincidence that that debating the Electoral College has come up once again, even aside from the fact that there have been 2 split elections in the last 16 years, which are sort of traumatic enough for the country. I think it's worth pointing out that debates over the Electoral College do tend to rise with these moments of new ways of thinking about what American democracy is. So with that, I think I would turn it over to the other panelists and open it up.
Okay, so let me ask Kate, from the perspective of constitutional law and moving away from the history a little bit, how many degrees of freedom do we have? I mean, there's some legal challenges. There's a question of whether a compact could ever be enforced. How do you see these things?
Yeah, sure. And if I could just elaborate just a little bit on the way that Jesse framed the problem. So we have these 2 events, right, 2 elections over 16 years in which the winner of the popular vote, right, does not, in fact, become the president because they are the loser of the Electoral College vote. And it's hard to know, I think, right now whether those are 2 isolated events, like we had 2 similar outcomes 12 years apart in the 1870s and 1880s, and then not again for nearly 100 years. So do we have that sort of 2 isolated data points? One winner of the Electoral College, George W. Bush, who loses the popular vote by about 500,000, and now President Donald Trump, right, wins the Electoral College and loses the popular vote by about 3 million. I think that, since we're having this conversation in the shadow of last week, there is a very real possibility that looking at the results last week, I think gives us real reason to believe that there's at least a chance that we could be looking at, if President Trump again runs in 2020, and a lot of things continue on their current trajectory, he could again be elected president in the Electoral College, but lose by a significantly larger margin than 3 million, right? If both turnout and margins in a lot of big blue states and in some of the kind of trending purple states, Texas, Arizona, right, others like that. So if 4 years of President Trump really gets Democrats out, we could be looking at a deficit in the popular vote of 5 or 6 or 7 or 8 million as opposed to 3 million. And that, I think, maybe does bring us to the kind of crisis point that Jesse sort of starts to identify. One other thing I will say, though, is that although that history, the recent history in which the Democrat wins the popular vote but loses in the Electoral College, suggests there's some inevitable political logic to that or something to that effect, it isn't necessarily the case that that's right. So in 2004, John Kerry, of course, was not elected president, but he narrowly lost the state of Ohio, and had he won the state of Ohio, he would have been elected president, though losing the popular vote by several million. So I think that's helpful in at least suggesting that, maybe it's the case that demographic trends are such that probably any kind of reform right now clearly redounds to the benefit of Democrats more than Republicans, but at least the last 16, 20 years of experience don't necessarily make that, I think, inevitable. So we are at this potentially building crisis point, and what are the options? I think that the constitutional amendment option that Jesse talks about it's good to bear in mind, right? It's never succeeded. The states, I think, maybe even as much or more than Congress are a huge obstacle, but there is this other possibility out there, this voter compact. And so sorry, Sam, now I'll answer your question. So what are the sort of constitutional challenges potentially that could be confronted? So we know essentially how this would work. States would enter a compact. Once you hit a tipping point of 270 states, the compact springs into action, and all of the signatory states decide to cast all their electoral votes for the winner of the popular vote, regardless of how the citizens of that state vote. So what are the potential constitutional arguments against the permissibility of this? One is the Constitution's compact clause, which says that no state shall, without the consent of Congress, enter into any agreement or compact with another state. So just the text of the Constitution, that provision, seems like an obstacle, but it turns out that this constitutional language has been read in pretty narrow ways, right? So the Supreme Court has basically said, despite the, and it's moving, it's operating, a lot of these decisions come down in a far less textualist moment. But they say, okay, so that is what the text says. But really, so long as these kinds of states enter into compacts all the time about boundaries and water and, tax agreements and things like that, and so long as those kinds of agreements don't undermine federal power in any significant way, they're not prohibited by the Constitution. So there's a pretty atextual reading of the Compact Clause that the Supreme Court has mostly offered that makes me think that the Compact Clause objection is not an insurmountable one. So certainly with the consent of Congress, no question this compact is, I think, permissible. And I actually think that under the court's interpretation of the clause, even without the consent of Congress, it's probably fine. So then you're left with, some less specific, specifically textually grounded objections, like it's just kind of inconsistent with our constitutional design and practice that the framers rejected, direct popular election of the president for a reason, and this is essentially an end run around the constitutionally designed process for selecting a president, that states haven't previously sought ever to assign their electors based on votes outside of their states, right? So there's like a federalism problem or something there. So you can imagine, at least in the first of those two arguments that I described, on this sort of U.S. term limits versus Thornton logic, where states can't, and there it was just individual states trying to impose term limits on their congressional representatives, and the court 5-4, and I think there are really good arguments actually on both sides of that case, says that states can't do that. So maybe, but it's kind of about general constitutional design and not really specifically tied to any particular constitutional provision. So you can imagine objections sort of like that. And then maybe finally a more pragmatic argument, which is that we don't have national elections, and so every state has really different rules around things like early voting and ID and things like that, and so it sort of doesn't quite work to act as though we have national elections when we don't. But that I'm not sure. A, if doing this meant we would do more sort of federal regulation of elections, that would be just fine with me. But B, I don't think that's a particularly serious objection. So, to my mind, the enforceability problems are the bigger ones than the sort of this thing being like unconstitutional ab initio for states to enter into. And that is just that if a state decides to pull out, what do you do, right? So if a state, so they get to 270, every state is like, okay, we're going to assign our electors to the winner of the popular vote, and then a state looks at the polling data and gets cold feet and decides, either after the election, to ignore the compact and send a different slate of electors, or to pass a law, right, just to undo it through an ordinary state legislative process, but pass a law that undoes the previous law they've passed, right, just to repeal the previous law joining the compact, and then the whole thing could fall apart, so then you could end up, I think, in a genuinely and maybe dangerously unstable situation in which you have real dispute about the outcome of a presidential election. And that's a scary possibility to contemplate, but so too is, I think, the trajectory that I just described. So this strikes me as the sort of thing that is a very high risk and potentially very high reward path to start down, and there's lots more to say, but maybe I'll stop there for now.
Rob, do you want to say something about that? Because I want to come back to you with ranked choice voting.
Yeah, I'll just comment quickly, because I've worked a lot on the National Popular Vote proposal, co-author with John Koza. It's originator of Every Vote Equal, which is a really terrific online free book. So check out Every Vote Equal. John Koza is this very rigorous thinker about these kinds of issues. He has like 9 ways to address the withdrawal issues and so on. So there's a lot of specifics, and it's on one hand like super simple, like the candidate with the most votes should win the election, and then on the other, any sort of implementation of sort of super simple things has a lot of questions to get asked. So the answering concerns part of that book, I think, is now up to maybe 120 pages or something like that. But the
500.
Just that alone, probably, yeah. So the just as an overarching point, just to keep in mind, is the Electoral College is not the current winner-take-all system by state, right? So that's just what we're currently doing, but it's not what the founding generation did, and even having popular vote elections, the first popular vote election where every state had one was 1872. So there's a lot of things that we assume are true that aren't true. But when you think about the current system, there are, since I got involved in 2004 on this, There have been multiple elections, 2004, 8, 12, 16. In the general elections of those elections, there are 34 states for all of those elections have not had a single campaign event or a single sort of meaningful campaign ad targeted at their voters. Think about that for a second. That's more than 2/3 of states. Most small states are sort of in that group. So that's the problem that sort of that relates to the lockbox issue, because it's the same states largely too. But just on the compact clause, I just would think about the fact that we actually often are wrong about what we think results are going to be. It's very hard to kind of look through scenarios where legislatures, say in September, would say, well, there's no way we can win the popular vote, but I think we could win in the electoral college system. So we're going to have a special session, and we're going to jam through a law in the middle of the campaign. Like some of these things are kind of what-if hypotheticals that I think become a lot harder. Post-election changes are even harder to do. But when we get to ranked choice voting, I guess we could hear about some post-election changes to rules that people want to see.
So constitutional lawyers, let's go to court, let's fight them. But a lot of the reforms that we heard about this morning, particularly the results of last Tuesday's election, what's kind of heartening about it is that these popular upsurges, even in conservative states like Missouri, took the form of democracy-enhancing results, such as on the redistricting commissions in 3 states. And so there's a question whether one of the things we should be thinking about more in our political process is the safety valve of direct democracy in some fashion. Now, I tend to be quite skeptical here because, a California colleague used to complain about the results in California because of the presence of initiative. But I said, how else could you get a commitment to really high government services at no taxes except by popular initiative? Because that's what people want, and legislators tend to think they have to balance a budget or something of that sort. On the other hand, it is a way of breaking up the domination of an old form of politics that has outlived its usefulness. So, Melissa, you've written about this at least some, and I always attributed this to you anyway, whether rightly or wrongly. So how should we think about this?
So it's interesting to me to have it, to think about this as a safety valve. And the question is whether, there are a couple of different questions. One is whether or not we might have good reason to think of it empirically actually as working as a safety valve for democracy, whether or not we think that that's actually what these various ballot measures have given us. And then we also need to think about it more holistically or philosophically from the standpoint of whether or not we actually think that this is what we want our democratic institutions to embody, whether we think that some sort of direct democracy reflection of the popular will is in fact optimal. And it would seem that part of the problems that the Electoral College is supposed to solve is the thought that we don't want immediate majoritarian decision making. And so I think we have to think about trade-offs there. So just to say, vis-a-vis the ballot measures pertaining to redistricting, I think the live question is whether or not these referendums are actually just going to enable partisan control by other means. So it might be the case that in fact they effectively take decision-making about district boundaries and such out of the hands of the legislature and place it somewhere else, which might be very attractive. Having independent bodies doing this work would seem to be just prima facie better than having it be subject to partisan control. The question is whether or not the redistricting plans as such, in fact, are immune for partisan control, and I think they vary. Even looking back to the Ohio district redistricting that happened in May, it still ultimately keeps legislative control over congressional map drawing. It's just a very complicated process. So you may know, there's a map proposed that's going to last 10 years until the next census, which requires 3/5 support in each state, 50% support from a minority party in both houses. If that fails, then a map is drawn by a 7-member commission, the governor, the state auditor, the secretary of state, plus 1 member appointed by the majority and minority of each house, requiring 2 minority parties' votes. If that map is rejected, a 10-year map passes with 1/3 or a 4-year map under a simple majority. Ultimately, my point is that it's still, in the end, provides for a mechanism of single-party gerrymandering and an incentive to hold out. So it seems, look, we've taken it out, we have this whole mechanism that's going to be bipartisan, but ultimately we have to see how it's going to operate. And it's not at all clear to me that it's going to solve that problem. We might also think, so the Michigan proposal, so there's something attractive about the creation of an independent commission, but it's still the person who's creating it is indeed the elected partisan Secretary of State, selecting 4 Democrats, 4 Republicans, 5 unaffiliated members. It's establishing new redistricting criteria, and some of them are obviously attractive, that they're compact, they're contiguous, that they're of equal population, but it also enables communities of interest to be created, and those are, by virtue of the fact that that's necessarily vague, they may be subject to manipulation, and it's not clear that they're not also going to be subject to challenge. So, and then there are other measures that seem to be more immune from these challenges. So we just have to see what the results are going to be. But it's not obvious, in some it's just not obvious to me, that subjecting this to referendum is a way necessarily of creating an independent mechanism that's outside of legislative control. More generally, we might think about these other types of referendums that are on the table. So there's this Alabama and West Virginia constitutional amendment referendums, which declare that the state constitutions don't provide or don't protect the right to abortion or require its funding. And these are going to have relatively little immediate effect given the current federal standing of Roe v. Wade. Moreover, it's also the case that in these states, access to safe and legal abortion has already been substantially impeded by other means, by raising various financial costs, delays, and so forth. And so what is actually the effect of these types of referendums? Is it purely symbolic? Is it designed to be forward-looking at a point at which Roe v. Wade is no longer the law of the land? That's not obvious to me either. And so what are we hoping to get from referendums? Well, it seems that it suggests that we believe that there's some sort of special legitimacy that derives from procedures that situate decision-making with ordinary citizens rather than representatives. But I think it's not entirely clear what that logic is. So legitimacy is, as is often discussed, it's an essentially contested concept. We often construe it as norms that oblige our obedience, or perhaps the obedience of elites. It might be just sociological, that we think prudentially that we're more likely to gain compliance with outcomes that are granted direct approval by a majority of citizens. But what is the normative force of it? So one possibility is that we think that via referendum, we're really engaging in self-legislation. But note that we're far from Rousseau. We don't usually think that representative democracy runs afoul of autonomy, of this activity of self-legislation. Nonetheless, if we're confronting fundamental constitutive ones, we might think that the direct exercise of decision-making on equal terms might be crucial to produce authoritative decisions, ones that we regard as rightly binding us. So we might think, okay, so what would that look like? It might mean that we need to ensure that we have citizens' equality. And we think that, again, citizens' equality in this direct sense matters in terms of creating authoritative decisions. But as we've heard, we have lots of institutions in America that derogate from formal equality, and we don't necessarily think of them as being at odds with any sort of commitments to republicanism or to democratic decision-making, or if they do, then we don't think about it as being fundamentally antithetical to what we stand for as a country. So why are we trying in these particular instances to grant people an equal vote? Well, it might be that we think that there's something that's so very important that the very identity or the capacity of the nation for ongoing decision-making, or the state for ongoing decision-making, is at stake. And that might be the case for these various redistricting plans, that our capacity for ongoing decision-making is imperiled unless we take this power out of the hands of the legislature. It's not obvious to me that that's the case for abortion or marijuana or crime victims' rights or any of these other sorts of things that have been subject to referendums. So this is all to say that I think if we're going to actually start appealing to this idea of direct democracy as in some way a safety valve, we have to think a little bit more about how it would operate. We would have to think about what do we need to see to mean that people are going to actually be capable of making an effective, meaningful judgment on these matters? What sorts of domains do we think that this judgment, that we think that people ought to be able to make a meaningful judgment about? And those views might be very different. We might think that people are able to make a meaningful judgment about abortion, but then we might think that that's the sort of decision that a legislature is also quite good at. So ultimately, if we want to think about these constitutive questions, I think it'll be crucial that we engage in a wider deliberative process at the state level, that we make sure that people are able to have the effective means of participating and shaping their opinions. Or we have to say, look, ultimately it's not capable of working as a safety valve. It's simply going to be another mechanism of partisan control or whatever, and say, ultimately we want our decision-making to be done by our representatives, but we want to improve the institutions by which our representatives are chosen, and some of that is going to begin with redistricting.
So Michael, you got the Electoral College. It's old. It's under some siege. It's probably failing in its in at least one of its stated goals of creating a national polity. You have redistricting, which was a reform so that the minority would get some representation, and now becomes a majority reinforcing tool and a minority disabling tool. You have the referenda, which was never much trusted in the United States, but was a backdrop even in the original Massachusetts Constitution, so it has some pedigree. So these institutions are all failing, and you run an organization that takes up challenges readily in the litigation framework, and with some greater reticence in other fora. So how do you get at these structural defects in our process?
Well, thank you for hosting this and for this conversation. And I was not here in the morning, so I apologize if I'm going over territory that's already been trod upon. The Brennan Center and our work over the past year actually touches on this very strategic question that Professor Zakharoff described. We were very involved in the litigation before the United States Supreme Court on redistricting, seeking to have extreme partisan gerrymandering, as we put it, declared to have crossed a constitutional line. We organized the Friend of the Court briefs. And as you know, the Supreme Court declined to act. Justice Kennedy basically said, come back next year, and then 2 days later retired. So it seems as if there's certainly less hope of a grand, dramatic constitutional ruling on this issue. And it's possibly not a coincidence that the same year, Brennan Center also helped write a number of these ballot measures on voting, but especially on redistricting in Michigan, in Missouri, in Colorado, and in Utah. The three of them passed, and the one in Utah, we actually don't know if it succeeded. It was ahead, and then it fell behind. And we're not alleging voter fraud, but that would be the appropriate thing to do, I guess, in this moment. There are numerous ways, I think, throughout history, the people have been deeply involved in constitution making and deeply involved both in the courts, but especially outside the courts, through referenda, through legislatures, and through the role of political parties in changing the way the democracy works and expanding the way our democracy is understood. I think that we are at, or certainly near, a moment of legitimacy crisis for our democracy, because these issues, this past election offers some evidence to that effect, in that redistricting reform referenda, for example, failed routinely 10 years ago, 15 years ago. People care about it, they know what it is, they care passionately enough about it to get these things on the ballot. In Michigan, where there is it's a redistricting commission along the California model, the party leaders from both parties and the labor unions and all the other political forces in Michigan told the citizen groups that wanted to push for this, don't bother. It's not worth spending the money. And so they went out and got 400,000 petition signatures entirely with volunteers in Michigan. On a snowy day in Michigan, you would see people standing by the road holding up signs saying, "Honk if you hate gerrymandering." And it overwhelmingly won. And so there is both deeper public understanding or concern about these issues than before. And I do think that while mostly people have focused on gerrymandering or something like Citizens United, or as we saw in this past election, voter suppression moves, as we would frame it, I think that the Electoral College is underlying, and its misfires, is an underlying and potentially even bigger source of discontent and withdrawal of legitimacy of all of them. It is really quite extraordinary, as has been said by the other panelists, not only to have two times where my understanding is, at least in the past, political scientists call this the wrong winner phenomenon, where the person who lost the popular vote became elected president, but it was within, I think, 40,000 votes in 2004 to have it three times. And this has been noted, but it has even deeper consequences than that. We now have a conservative majority on the Supreme Court of a type we have not seen since the 1930s. One party, the Democrats, won the national popular vote 6 out of the last 7 presidential elections. But 3 out of the 9 Supreme Court justices were nominated by Democratic presidents. The misfires of the Electoral College have a big impact on the future composition of the Supreme Court for decades to come. All of this is coming together in a way that, for a large part of the country, and it may be a partisan thing for a lot of them, this seems like an utter misalignment of the governing institutions with the will of the people and what people's expectation is of that. One of the answers it comes through the courts. As I say, we tried, and others tried that. Paul Smith argued the case on redistricting. Professor Zakharov has been part of a group of really prominent and creative legal thinkers in trying to bring a constitutional challenge to winner-take-all in the states. I hope I'm not scooping you, but this was 4 states, 2 Democratic and 2 Republicans. The first ruling by a federal court on this came in California recently. It was the Rodriguez case. It did not accept it, rejected the challenge. It relied on fairly strong language, I would say, in previous Supreme Court precedents, though of course the Supreme Court can change its precedents. But what's noteworthy is that although the language of the Constitution, the ruling said, and the language of these rulings was pretty strong and pretty clear, and I wouldn't take too much wiggle room out of that opinion, it said that this was justiciable, meaning it was not a political question that should not be heard by a court, but was actually exactly the kind of thing that a court could hear. And that was, if that is the view held by other courts as well, that does open up interesting future avenues on this. The national popular vote, which I'm not going to preempt that, what's interesting about that is when one makes the argument that, well, the Constitution was intended to work with this intermediate body of wise elders or whoever choosing the president. In so many ways, of course, the Constitution does not work now, has evolved to work differently from what the framers thought at the time. And it's often been the case that while a lot of this has come through constitutional amendments, very often preceding those constitutional amendments, there were workarounds. Workarounds just like national popular vote. The 17th Amendment, which gives direct election to senators, that was their version of campaign finance reform. They thought that the state legislatures were bought and sold by the interests, and they were, and that the way around that was to give the popular vote to voters of the states for Senate. And so numerous states created systems through popular pressure where there would be basically an advisory referendum on who should win the Senate seat. And this was extra constitutional, but it created enough senators who were basically popularly elected that they then voted for the 17th Amendment when the time came. Similar things happened with the right to vote for women, and so before the 19th Amendment. So this interplay between public constitutionalism, it's more than a safety valve. It's actually a pressure point that has very often through our history been a way that democracy has expanded itself. I will say finally that I am equally worried about legal and constitutional challenges to some of this creativity. These ballot measures the other day, any ballot measure on the Electoral College could very well be challenged as violating the Elections Clause or other parts of the Constitution. It was a 5-4 ruling just 2 years ago by the Supreme Court that upheld the constitutionality of ballot measures on redistricting for federal office. The Arizona legislature challenged the Arizona Redistricting Commission and said that the Elections Clause, which says the legislature sets the time, place, and manner of elections, by legislature, what they meant was those guys in bad suits under a dome, not the people as legislators. And it was a 5-4 ruling, but Justice Kennedy was in the 5. And so we don't actually know, and we'll fight really hard on this, where this Supreme Court locked into place by misfires of the Electoral College will come down on this. I'm as worried about defending the democracy movement from the courts as I am optimistic about enlisting the courts as an ally in it.
Can I,
Yeah, that's a...
Sam,
yeah,
could
go
I just
ahead.
add, I just wanted to build on something that Michael was just saying. He pointed out that to return a moment for the Electoral College, that to the extent that it was designed as a body of wise elders who would make this decision, it doesn't function today like it was intended to. The first thing I would say is that that's absolutely right. It didn't even function within 10 years of the Constitution's ratification like it was intended to, because political parties developed. The founders did not anticipate those. And as soon as you had political parties, you had people siding with one or the other, and it was tribal, in the words of John Haidt. It was a tribal decision rather than a sort of a deliberative decision. I think it's an important reminder that to the extent even that was one of the features of the original Electoral College, it was gone almost immediately. And so the other point I just wanted to make about that era, and I think this came up in the quote from Madison that was on the screen earlier about the concerns of direct democracy, is something that Professor Schwarzberg mentioned. I actually think there was a lot, the founders' views of direct democracy were a lot more complicated. And actually, at the convention, several of the delegates were quite strong advocates of a direct popular vote for president. And these delegates were named James Madison, James Wilson, and Gouverneur Morris. These are not backbenchers, you know. These are the most important delegates at the convention, and they all. I pulled up some quotes, and these are quotes either from the convention or from times contemporaneous. Madison said, "The president is to act for the people, not for states." James Wilson said, "Can we forget for whom we are forming a government? Is it for men? Is it for men or for the imaginary beings called states?" And Morris said, "If the president is to be the guardian of the people, let him be appointed by the people." They were quite clear that I don't think they were troubled by direct democracy in the way that we often think that they were. After all, House elections for the House were direct elections. They were perfectly open to that. It didn't win for the reasons that we talked about earlier. There was an alliance of small states and slave states that fought it back. But some of the most important and influential minds at the convention were absolutely on board with a direct popular vote for president and would have done it that way. And they said it. Madison himself said it explicitly. He said, if it were up to me, we would do direct election. It's the best way to do it. But the slave states will never go for it because of, he says, on account of the Negroes. I mean, it couldn't be more explicit, the reason that they're doing this. It's a political compromise. It's not about high principles. So I think we just need to always keep that in mind when we talk today about what are the purposes that the Electoral College serves and who was in favor and not in favor of a popular vote even 225, 30 years ago.
So let me shift this a little bit to Rob, but I want to introduce it in the following way. There's always a tension in democratic governance. On the one hand, you have to create bodies that are capable of governing and capable of realizing an operational group. And so we heard in the second panel today that one of the crazy reforms in our nominating process is to have all proportional representation in the primary states of the Democratic Party, which means there's no early obvious filtration mechanisms that starts to consolidate a governing person, meaning a candidate. And so you may have a great deal of chaos going into the nomination process. On the other hand, you want to worry about giving too much power to a single winner. And so there is a tension that you want a majority to be able to form and to govern, but not too much. And so how we do this has been a delicate issue in American political thought for a long time. The first elections for Congress were generally done on an at-large statewide basis. And when Pennsylvania had a tightly split delegation, a tightly split vote between Federalists and Anti-Federalists, but one party got all the congressional delegation, that was considered a defect. And so our current system of single-member districts, as the product of a reform and a compromise in 1842, was an attempt to take back some of the over-rewarding of the majority. But now that single-member districts create other dysfunctions. It's the gerrymandering incentive. It's the fact that if you have 55-45 in a state, there's no guarantee that that 55-45 won't be reproduced across every single one of the districts, and then the 55 gets 100% of the representation. So how we temper that has been a source of ongoing debate in our country, and the current system we have was not always the system we had. And for Congress, it emerges from 1842. At the state and local level, it is largely, not entirely, but very heavily a product of post-1982 reforms in the Voting Rights Act, which addressed the question of the ability of minorities to get elected in single-member districts. So these are artifacts of trying to cure the initial defects in design. And so now the question is, if they're not given, on the tablets from the temple from Moses, if they're not enshrined in some kind of natural embodiment, there are mechanisms, and we may not know how to get there, but there are mechanisms of reform. And I think that the events in Maine right now bring into some relief both the use of popular referendum as a safety valve and the capacity to have alternative voting mechanisms. So amazingly, the New York Times editorial board came out in favor of ranked choice voting. David Brooks, so you got both sides of the Times back pages now endorsing this. So what more diversity could we have? So Rob,
Center left, center right.
Yeah, well, good. Well, thank you. Just to echo Sam's basic point is that the founding document says almost nothing about how we should hold elections. And really, the fact that it has to be elections for the House, as Jesse mentioned, but what we do is entirely up to the states. I mean, there's certain guiding principles that we have to uphold in the Bill of Rights and equal protection. But there's a lot of leeway and a lot of history. And one of the Times editorials also was on House size, which I know was a question this morning. But why do we have 435 members? Because in 1910 we just stopped talking about the fact that we can change it after changing it every 10 years up until then. And that's true of a lot of things. We used to talk about them, we changed them, and then we sort of go through a generation of not doing it. And then there's some expectation that goes back to James Madison, who in fact was a real kind of fascinating thinker, following the latest breaking creative ideas of the time. And that's really what the founders are all about, which is not being sort of stick at home and not thinking about changes. So we have a lot of space in the laboratories of democracy, and the states are very active on changes to how we vote. You've got the top two primary in California. You've got the Louisiana system where they have no primary at all but a runoff. You've got the laws that are changing that Michael was talking about with sort of all these sort of fascinating innovations for changing. So, ranked choice voting, how many know about ranked choice voting, instant runoff voting, just as a start? Oh my goodness, you don't read the Times?
Not the editorial page.
Not the editorial page, right, just David Brooks. Oh, well, you missed that too. You almost actually got to vote on it here in New York City. If you're a New York City voter, let me see if I can get a hand raised on something. Are people New York City voters? Right. Exactly, but the Charter Commission seemed ready to put it on the ballot. It's sort of a vibrant issue in lots of cities and states in the sense of bipartisanship. A bill passed in Utah to allow their cities to do ranked choice voting, and several of them are debating it right now to use next year. We've got 11, 12 cities using it, another 5 that have voted to use it this year, sort of moving forward in their next election. And Maine is using it for their congressional elections now, this month, U.S. House and U.S. Senate, and they did for all their primaries back in June, including these hotly contested gubernatorial races. So the idea of ranked choice voting is that if you have 2 people and you vote for one of them, you've been very expressive, right? You've said, I like this person, I'm not voting for the other person. You add up the votes and someone's going to have more than half the votes, and you have kind of a pretty clean outcome. In the shocking possibility of having more than 2, which did happen, say, in the Republican presidential primaries, is sort of one example, right? There were more than 2 people that sought the Republican nomination. When you added up all those votes in those nominations, you didn't get to a majority of a primary vote until late April. And because the vote would be spread among a lot of people, right? So people were winning primaries and a certain person winning most of them with, 30%, 35%, 38%, and so on. Ralph Nader debates, and Jill Stein and Ross Perot, and sort of the entry of third-party independent candidates can kind of cause major party people to do twists and turns. One way to deal with that is to have a second election, right? To say, okay, well, there's 3 or 4 people, no one got half the votes, let's have a runoff, right? Let's have a whole separate election. And a bunch of southern states actually do that for their congressional primaries. There's a history of actually that being more common for other primaries. In fact, Maine, which now does something different, in the early 1800s had runoff elections. But just to give a window into how things were different then, is you look back at the data and you said Maine would have a runoff election, and then they wouldn't get a majority the next time. Then they'd have another runoff election. They would sometimes have 5, 6, 7 runoff elections. And you look at the results and say, why didn't they figure out how they could just have 2 people go to the runoff? But the fact is, remember, there was no printed ballot, right? There was no way to control candidacies. Politics was very different, and as sort of over our history. So that was one reason we don't have runoffs, is they were kind of a pain. And people sort of adjusted to allowing people to win with less than half the votes, not really based on principle, but sort of based on just almost logistics. And that's kind of where we are, because runoffs can be difficult. And actually, in all those southern primary runoffs, we looked at the last 200 of them, and turnout dropped in 96% of them. And the average turnout decline was more than 35%. When New York City has runoff elections, like in the 2013 public advocate race, turnout just plunged to single digits. And so that's one of the reasons why people are talking about ranked choice voting for New York City. The other piece of the puzzle, though, is that if you have an opportunity to do something different, to express your support for more than one candidate, that actually changes incentives for candidate behavior. And that's what we're starting to see with ranked choice voting. So what you do with ranked choice voting is, instead of just indicating that single choice, you get to express preferences. You get to rank the candidates in order of choice. You can say, here's my first choice. However, I do have a backup choice, and that's my second choice. And you think of it as a backup. Here's my third choice as a backup. And then you might be 3 or 4 more candidates say, I'm kind of indifferent about the rest of them, I'm going to stop. Or you say, I really don't like one of those people, and so I'm going to rank everyone ahead of that person. You're sort of being more expressive. You add up all the first choices. If you get a majority win of votes in the first round, you're done. So this is the majoritarian winner-take-all single winner system. And so 50% plus 1 wins. But if you don't have that, like all those early Republican primaries, or the 2000 presidential race in Florida, or you can pick your target, you would say, well, you're not done yet. Let's defeat the candidate who's in last place. So, sorry, they're out. You look at their ballots they're cast for that candidate, and you add them to their next choice. And if you get a majority win, then you're done. If not, you rinse and repeat. You take the next last place candidate, and you go up the ladder. What we're seeing as candidates are adapting to this is they just sort of toss out the traditional playbook of sort of focusing on their base and maybe looking at some undecided voters and attacking their opponents to try to drive away their base, but try to actually engage with more voters because your second and third choices might be determinative. So what you're often seeing, like San Francisco uses it as one of 4 Bay Area cities, Oakland and others. They just had an open seat race for mayor that was won by London Breed, who became an African-American woman mayor of San Francisco. And it was actually a very interesting election in multiple ways, but one part of it that was important was that it was seen as a somewhat polarized choice between her and these 2 other candidates who had formed kind of a coalition, kind of electoral coalition of saying rank us first and second. But she actually earned a second or third choice ranking by half of her top opponent's choices because she had looked to make a connection because that might have been important for her to win and was actually ranked first, second, or third by more than 60% of San Francisco voters. So she got an affirmative expression of support from more San Francisco voters than any mayor in the city's history. And you often see that kind of connection that people have to do with the system. So it's sort of solving a particular problem of like, how do you handle more than 2 choices? So the discussion earlier about, well, can we have third parties in the United States and independents? Well, no, because the fierce partisanship tendencies will make it hard to achieve that. Or you can kind of relax the voter and give them the chance to kind of express their preferences. How it passed in Maine was tied to the fact they've had a series of pretty controversial elections for governor. Actually, this year they got a majority winner for governor, but 9 of their last 11 elections for governor have been won with less than that. Their 3 previous governors had all won a race with less than 40%, one of which was Paul LePage, who was a particularly controversial governor who's just leaving office now. And it kind of created a conversation about whether it was right for him to win with 37%. And so there was a history of using ranked choice voting in the state, in the biggest city of Portland, and they put it on the ballot in 2016. It won. It's had an incredible legal and political stretch of time since then, but the long and short of it is they had to vote on it again, and then the legislature acted, and the courts have ruled, but they are now using it for their primaries. It was a meaningful use there, and for the general election. The second congressional district, which is the northern district in Maine, which is a really interesting one because it was an Obama district that flipped strongly to Trump, and actually that mattered because if you win that congressional district in Maine in an electoral college presidential election, you actually get that elector vote, so it was kind of noticed. But it became the most expensive congressional race in the country this year. With an interesting element. They were using ranked choice voting with 2 major party candidates and 2 independent candidates. The 2 congressional districts in Maine ended up with the third party / independent vote being higher in those 2 congressional districts than all but one other congressional district around the country where there were 2 major party nominees. So people were sort of expressing themselves more. And it was very, very close between the top 2. Republicans slightly ahead, which is like 46 to 45.5 of the first choices. And so those independent candidates' votes are going to be the final determining outcome. And there was an exit survey that was done that sort of shows they're very likely to break heavily toward the Democrat, who did a better job of kind of making an explicit sort of reaching out to those voters. And so the Republican actually just yesterday, they're just at the end of the count, and we can say why it's taken a while, but the gist of it is that they have lots of small towns that count ballots by hand, and they have to move these ballots to the state capitol to count the instant runoff. But they're sort of preemptively trying to stop the count. And so a litigation that was sort of this post-election say, well, let's actually not do the system that we all just were running an election with. Let's just use the first choices. And that's in federal court right now. There's little expectation it will succeed, but it is creating some discussion and change. But I will say it's a tool that I think is a very powerful tool for a lot of things that we've talked about today. It can be applied in different ways. And most dramatically, as the Times editorial on Monday was sort of laying out, the multi-winner proportional version of this would really be a sea change in how we vote for Congress.
So, Kate, let me ask you a question about that. One of the problems we have when we talk about the constitutional parameters is that our Constitution is very old, and it underspecifies democratic politics. It's basically not addressed. And for some of us, like me and Rick, it's been a very good career move because it lets us try to guess what it might mean, and people reward us for that for some reason. I read the complaint filed by the Republican candidate in Maine, and it was, it would not have done well in my class. Its basic argument was this is different, therefore it's unconstitutional. And that's kind of silly. There's some intuition there, but it's silly as a constitutional doctrine matter. But how many degrees of freedom do we have under the way that the court has constructed the Constitution? You can read into it sort of a protection of the two major parties, sort of a reluctance to experiment with too much that's different, sort of a distrust of any kind of expertise. So where do you see the lines in all these, so whether it's the Electoral College or initiatives or ranked choice voting, where do you see all these lines?
Yeah, I think there's a pretty ungrounded but sort of reflexive skepticism about novelty that you do see emerge from time to time, and not just in kind of law of democracy cases, but you think about the first big constitutional challenge to the Affordable Care Act. It was a little bit about, well, our Commerce Clause jurisprudence maybe doesn't necessarily permit this, but it was also just like, this is just different, and that seems wrong. So I think there is that reflexive but misplaced skepticism about novelty. But I think that there are parts, it would be very difficult, I think, for the court to bring that attitude to some of this, especially with respect to the Electoral College, because, the college is created by the Constitution, although the language, the term Electoral College isn't there, but each state is very explicitly given, the legislature of the state is explicitly given the power to elect the method by which its electors are chosen, and then those electors cast their votes for the president. But I think it would be difficult to read many limitations. Now, maybe the limitation that is applicable in the Arizona Redistricting Commission case, right? So if it's the legislature that chooses electors, if we're having by popular initiative some change in the mechanism by which electors are chosen, potentially you have the same kind of challenge, or textually grounded challenge that you saw in the challenge to the independent redistricting commissions that were adopted by ballot initiative. But that's the only one I can really see. Other than that, the whole idea was that states were to be given a decent amount of freedom and latitude to experiment with respect to how they would assign electors. And indeed, right now we've all been talking about winner take all, but as Rob just alluded to, right, 48 states do have winner take all, and Maine and Nebraska do something different, right, which is to give, Rob, you should correct me if I'm wrong, but right, they give the statewide popular vote winner two of their electoral votes, and then the remaining 2 or 3, right, go to the district winners in each of those states. And that, I don't think there's a serious constitutional challenge that could be brought to that. And so this is definitely something, as we're sort of trying to dream big about what the possibilities might be. So, big would be constitutional amendment, and big but different would be this interstate compact. But it does feel like at this individual state level, there is significantly more latitude for experimentation. So you could imagine states, a number of other states doing what, I think it's in the 70s in one instance, and the 80s in the other instance, that Maine and Nebraska adopt their respective, something like that. So, but they happened independently, and no state since has decided to try something, at least until Sam is successful in this litigation, but states haven't done anything but winner take all at the state level. So you could imagine another state just doing, it's actually sort of to throw a question back to Rob. One question I've had, I don't know if you want to speak to this, but so to the extent that a lot of states get totally ignored in the presidential campaign season, do the states like Maine and Nebraska, which actually have districts in which there's potentially real contest, I guess, would that be one way, a sort of small scale attempt to move away from winner take all, which is just to have particular states identify some number of districts and maybe swing districts, so that if so 2 or 3 districts that could, where the elector would follow the district winner as opposed to the statewide winner as currently stands. And maybe that's enough to attract at least some attention in presidential campaign season to states that otherwise get literally no visits or, maybe occasional fundraising visits. So that's one. And then the other, which is not totally responsive to your question, Sam, but since we're short on time, I thought I would mention this faithless electors issue, right? Which is a totally different approach. Not trying to amend the Constitution, not trying to do a compact, not even really trying individual state-level structural reform, but trying to convince electors within the confines of the existing system to cast votes as their consciences dictate, as opposed to necessarily consistent with the popular vote in their state. And there have been a handful of so-called faithless electors over time, right? Electors who don't vote as state law or the popular vote total in their state would direct them to do. And as I read it, there's actually kind of an open constitutional question about whether they're permitted to break with either, again, state law or state popular vote totals. And there was a little bit of an effort in 2016 to try to convince Trump electors to break and vote, to cast their votes for Hillary when the Electoral College actually assembles in D.C. But there's some litigation ongoing about that question, and that seems like a totally different strategy that I think has both promise and peril too.
Michael?
Yeah, I wanted to react to what Professor Shaw suggested, which is that if other states move to what Maine and Nebraska have, which is allocating the electors by congressional district, that there's not much of a challenge constitutionally or legally that could be brought to that. I'm not sure I agree with that, and I certainly hope that's wrong, because this is actually
What about
something...
McPherson v. Blacker type arguments, which is basically that reading as the legislature shall direct quite literally.
Well, I think the interesting question is whether both the constitutional, and this goes to what the case you brought, both what later constitutional doctrines say that put a gloss on what it means for the states to make that decision, or federal laws like the Voting Rights Act. Where this plays out in a real way is that in recent years, although it has never moved forward, the Republican Party in Virginia and Pennsylvania and Minnesota has tried to move to voting by congressional district, but the electors being assigned by congressional district. And what that would do, the reason they want to do this is what that would do is it would in effect gerrymander the presidency. It would mean that those states are no longer winner take all, and that whatever balances or imbalances there are in redistricting, some of which is gerrymandering and some of which is just that minority voters in particular tend to be clustered in cities, would play out in the presidential race. It's not entirely clear over the long run who it helps politically, which party it helps, but certainly the Republicans in this instance thought it would help them. And I do think that there would be arguments certainly that would be dilution of the meaningful nature of a vote in an urban district for those people compared to what they have now, which is the chance to vote at least for their states.
Would you say the same thing about ranked choice voting? Because if you start...
On a statewide basis?
No, on a city basis. If you start introducing it in urban areas, it could have impact along Voting Rights Act considerations.
Well, until recently, it would have been considered by the Justice Department in advance and was cleared by the Justice Department when it was brought up in various places, I believe.
It was only allowed, as I recall it, only allowed as a remedy to an established Voting Rights Act violation, and not, I don't know that the Justice Department passed on it from the beginning. I just don't know. Guy's looking at me as if...
Yeah, there was
Right,
one interesting ranked choice voting thing with the proportional version of it. Used to be used in local school board elections in New York when it was covered, and the city tried to move away from it, and that was the last time the DOJ denied preclearance moving away from ranked choice voting for those elections, because they were in fact providing, sort of upholding voting rights in very clear ways. But I think because I'm speaking, I'll sort of talk about the congressional district system, which is one, it is a part of our history, and the reason we don't have divided systems that divide electors by state is sort of a game theory, right? Which is that when states did divide electoral votes, it's kind of what Michael was pointing out. If some states do it and some don't, you can start kind of getting different kinds of outcomes. And if you're dividing your electoral votes and some other state isn't, you're not maximizing your help to your side. So we moved that direction, but actually early on that wasn't, many states didn't do that. But we're sort of in a mode right now where we're kind of trapped in a certain psychology where I think like if some states tried to do proportional, say the Larry Lessig, Sam proposal, that same conversation would happen. Like, well, that's going to have political impact that state's doing and the other isn't, right? Unless they all do it. But then if they all do it, there's sort of other issues. So that's
That's the
sort of
history
where
of how we got single-member districts, because initially we had mixed systems. Some states had at-large elections for their congressional delegation, meaning one election for all of them, and some states had single-member districts. And what they found was that the states that had single-member districts had split delegations, so they didn't have as much power in Congress as the states that had proportional, one shot, everybody takes all, which tend to be the smaller states. The smaller states were outperforming the bigger states in the Congress and getting results from the early Congress. And then some of the middle-sized states decided, hey, we can play this strategy also. And I think that when North Carolina finally decided to go at large in order to leverage itself better, Congress said, we see where this logic goes. And so they passed a law that was basically Ulysses and the sirens tying yourself to the mast. 1842 says, okay, nobody's going to play this game. Everybody goes single-member districts. And we've been living with that, but it's just a statute. And so it can be amended. We could have ranked choice voting and other mechanisms for Congress. There's no constitutional prohibition on that.
in fact, the Fair Representation Act, H.R. 3057, would do just that.
Okay, we have time for some questions from the audience. If anybody, yes, ma'am.
Thank you. This has been wonderful. Question mostly directed to Jesse because of the wonderful history he gave about the Electoral College bill dying in 1970. As you know, there was that panel. There was a discussion at lunch about the changing times. So you gave the reason why it died. First of all, things are different now. Not as much filibuster. Certain rules have changed, and I'm just curious what your opinion is. While we don't quite have Strom Thurmond for sure in segregationists, if a bill were to be worked through, what are the chances, and if it still would fail, why do you think it would fail?
Prognosticating in this environment is I think, a fool's errand. But what I'll say is, I think it failed because of the filibuster. The filibuster is still alive and well for legislation, so there's no reason that it couldn't fail again for that same reason, unless somebody, won't name names, kills the filibuster for legislation, which you could see happening over the next few years in the sort of ratcheting up of the partisan warfare. But let's say somehow you have majority. I mean, first of all, what you need obviously is, you need supermajorities, right? You need 2/3 of both houses to move any amendment out to the states. It's not that I agree with you that things have changed, but the degree of polarization and the degree of sort of 50-50 polarization, which is what we're seeing. I'm sorry?
And who it benefits. Many more Democrats now. So maybe the
Right.
Republicans are not all segregationists, but they're taking the place of that.
Right. Right, and as I think Professor Shaw pointed out earlier, you could make the case to Republicans that they're endangered too. Look at 2004. I would say the country's changed even since then, and making that less likely. But yes, it's hard. Democrats would, in the short-term, benefit. I think the best case you can make for it in the long term, really, and the way that you could really propose this as an amendment is, over the very long term, which is not how politics happens, unfortunately, you really do see an evening out of voting for the two major parties. Look at from 1932 to 2008, inclusive, the presidential vote, there were about 1 billion votes for president. You know what the separation between the votes for Democratic candidates and Republican candidates was? 700,000.
Wow.
Yeah, that's like the population of Alaska with 1 billion votes. So if you have a wide enough lens, the country is actually pretty balanced, and you could really see it over time, it going both ways, like the Electoral College harming or helping both parties, it's a very hard case to make in the immediate future. We all only live for a few decades, or you know, it's hard to get politicians to look beyond their self-interest. So why I'm not focused. I mean, Birch Bayh's effort was valiant. I don't think it's going to happen again.
Sir?
So I'm certainly an advocate for the popular vote for a president, but at least now we're limited to recounts in Florida and maybe one or two other states. What do you think would be the practical effect of a really close election nationwide? I know it would be a boon for us lawyers, but how do you handle that in 50 states at once?
You know, you only get Florida in 2000 because of a cliff effect, that last marginal vote delivers 30 electoral college votes. If you have 150 million votes cast for president, the chances of being within a countable number are really, really small. Now, it's true, if it was one vote margin, we would have full employment act for the lawyers for a full 4 years thereafter. But, you know, it's the compounding effect of the winner take all and the electoral college block distribution that really causes the problems that we have. You rarely get elections at a national level that will be within that margin. And even Florida and Georgia today, it's only artifacts of very particular factors about those states. You know, the runoff in Georgia requirement, or Florida is incompetent. You know, it just is.
Just a little tag, Sam, which is just simply that it's one of these sort of head-in-the-sand ways that our members of Congress deal with these kinds of issues, because they could pass federal laws to make it much better. They could exchange the date of when the electors vote a little later. They could give more money to states to prepare to run recounts. They could sort of set regimes that would actually help us a lot right now, because we are really in a potential problem right now if we get a close state, just like we were in Florida in 2000, and that same regime could help us do nationally. Certainly no other country that has national popular vote, like Mexico or Brazil or someone, would never say, oh, we're not going to do that because we can't do a recount. They just come up with a way to do recounts.
Yes,
Okay.
Go ahead.
Chime in, just one more thing. Yes, extremely unlikely, but I think not impossible that you could end up in a genuinely disputed election scenario. And then some of these kind of like really terrifying possibility. I think, you know, if you say you have a third party or you don't have a winner in the electoral college, then you have this mechanism by which the House decides, right, the winner, and it's each state getting a vote in the House. So it's not even the delegations, right? It's each state gets one vote, each state delegation. And if they can't decide, someone should correct me if I'm wrong about this, the executive, am I right? There's if the House can't decide, the
Senate
executive
picks the vice president
And the
on
vice
a one
president sits.
senator, one vote basis.
Right,
And
but-
that person could be acting president.
Could be acting president.
While the states, right, like the executive in a single, anyway, it gets very messy very quickly, and I feel like that's extremely low probability, but especially when we have an environment in which our current chief executive has sowed a lot of doubt about the integrity of our election system in general, it could be, I think, dangerously unstable state of
But
affairs.
keep in mind, the framers thought that the House was where the presidential selection should be resolved.
At least frequently, not all the time, but
Yes,
yeah.
but so
And very, very quickly, one of the reasons that they almost passed the constitutional amendment was, in addition to the broader social factors that Jesse mentioned, was that in 1968, there was a big fear that George Wallace's candidacy would send the election to the House. And in the end, his vote collapsed, and a lot of the blue-collar Democrats went back to Hubert Humphrey. But Richard Nixon and the Republicans were major supporters of ending the Electoral College because everyone knew the House of Representatives was always going to be controlled by the Democrats, and that couldn't be where the decision could possibly be made.
sir, last question.
Given all of the problems with the Electoral College, doesn't that argue for us to reconsider the Australian way of doing things, mandating a vote, and I realize Americans don't like to be told anything, but to pay their taxes? We do have a very high rate of voluntary payment of taxes, the president notwithstanding.
I don't have to
And doesn't that take us to the first step? Because if more people vote, the states that are ignored by the political candidates will express their opinion with more numbers. And I wonder what the panel thinks of that.
Well, it's not, oh, sorry.
Listen.
Okay, well, I think mandatory voting is an interesting and complicated question, and it's true that Americans don't like to be told what to do. It's not clear to me that it solves in any way these problems of the broader design of the Electoral College, except that, especially in a winner-take-all system, it may make it clearer what the mandate is in a particular state, but that's the effect it's going to have. But I think if you want to think more generally about what a mandatory voting system would look like, it might be, I mean, the major cost that, apart from financial and personal costs associated with voting, a lot of the time what comes up when people worry about mandatory voting is that the number of people who are voting in a way that is unreflective may increase. Now, it might be that once you have a vote, you take it upon yourself to educate yourself, so you're not casting an uninformed ballot. But I think one worry, and this is the way it connects up to these other sorts of issues, is that we might want to think that people are able to self-select into their level of information, their level of knowledge about political issues, and turn out if they feel that they really have a clear view, and stay home if they don't. And so if we want to think more generally about what it means to have an informed, educated electorate, again, I think we have to think more systemically about what we want from our elections and from our democracy more generally. And it's not clear to me that mandatory voting actually is going to get us there.
So there was a claim made in the last panel by Rick Pildes that the Australian experience is that mandatory voting pushes voters toward the center and pushes the parties toward the center. I'm originally from Argentina. Argentina, all countries that start and end with A have mandatory voting except for Austria. And it's a well-known rule of political science. And Argentina has mandatory voting, and I would defy anyone to tell me about the moderation of Argentine electoral politics as a result. I think to end the program for today, whatever system you have will come back and bite you in the ass somehow. This is where I've concluded. Thank you very much.